We've made it to the offer to purchase and contract. So this is the North Carolina Standard Form 2T, and this is where we handle all of our negotiations. So all of the basic information goes on here. When everything is agreed upon, it becomes an executed binding contract that we send to the attorney and a lender if they're involved. The top part of the form is pretty self-explanatory. The seller's info, the buyer's info goes in, and we fill out the property information. So we consult the tax records and the deed book. The real meat and potatoes is on section D. So that's where we put our purchase price, what the buyer is offering, and we start our negotiations. There are two deposits that we need to discuss. The first deposit is the due diligence fee. Due diligence is a very important thing in North Carolina. It's available in South Carolina as well. What it is a negotiated period of time for a negotiated fee that allows the buyers to do their inspections, secure their financing, and decide if they want to purchase the home or not. During the due diligence period, buyers can terminate the contract for any reason or no reason at all, and the seller gets to keep the due diligence fee. This is where we usually have the most amount of questions, and I'm happy to discuss this further in detail with you. The second deposit is less risky. It's held in escrow by the closing attorney and is called the earnest money deposit. This comes into play once that due diligence period expires. The earnest money deposit is the buyer's skin in the game through the closing. There are some additional options for additional due diligence and earnest money deposit, but we typically don't worry about those. On the second page, we discuss the earnest money deposit, establish the escrow agent, usually our closing attorney, and the effective date. Due diligence fee, due diligence period, there's additional discussion on that. At the top of page 3, we establish the length of the due diligence period, if it's going to be a calendar date or a set amount of days, and we determine the settlement date. Now again, until this is a binding contract, all of this is negotiable. So upon closing on the property, everything is dispersed by the closing attorney. There's a small section about special assessments. That's where the HOA charges a fee to homeowners. This will be brought to our attention by the seller's agent. Special assessments default to the seller. At the bottom of page 3 and getting into page 4, we talk about exclusions. Now, certain things automatically convey with a property, your major appliances, your stove, if it's a built-in microwave, anything that's bolted to the walls. So curtain rods, bathroom mirrors, bathroom toilet paper holders, stuff like that, mailboxes, all of those things automatically convey. Things like washers and dryers and refrigerators are negotiable. We've recently added a section on unpairing devices, things like your Ring doorbell, speaker systems, all that good stuff. Want to make sure they're ready for the new buyer. There's also an opportunity to list any items that specifically do not convey. We can talk about that. So TVs, TV mount kits, stuff like that. The top of page 5, there's a section for personal property that will convey with the home. So this is where if a refrigerator, washer, or dryer, stuff like that will automatically be included or submitted here. The rest of page 5 discusses the due diligence period, where the buyer gets to investigate the property, do their inspections, and secure their financing. It's advised that buyers get a survey on the property so they know the exact lot lines. Page 6 covers if there's an existing lease on the property, the buyer's obligation to repair damages during their inspections, and the buyer's right to terminate. Upon closing, the buyer is accepting the property in its current condition. Section 5 discloses the buyer's means to purchase the home, if they're using cash or financing, and the type of financing if that applies. Page 7 is important. It discloses if the buyer has to sell a current property to qualify. If there is a contingent sale involved, it goes on to say if the home is currently listed or if they're just now getting the ball rolling. Page 7 also covers the residential property disclosure statement completed by the sellers to the best of their knowledge and the mineral, oils, and gas rights disclosure. These documents are provided by the listing agent and should be available to you on MLS by your buyer's agent. Page 8 reviews additional buyer obligations, seller representations, how long they've owned the property, further discusses buyer obligations, responsibilities, authorizations, and seller representations if they've owned the property for at least a year or not. Lead-based paint is also disclosed. If a property was built before 1978, this additional disclosure and document is. Page 8 also covers HOAs. If there's one in the community, then we'll need to know. Now we get into HOA fees and frequency and if there's CCRs. We don't see fuel tanks too often, but this is the section of the contract where we disclose it and discuss who owns the fuel at closing. There's a checkbox if the property is subject to any lease, and then we start to get into the seller obligations. Here, seller obligations include authorization to disclose information. They have to disclose any material facts or information that is important to them. They have to provide access to the property. Reasonable access means that you can schedule an inspection and the home will be ready for the inspector at the agreed upon time. The day of closing, the property should be free and clear of any seller's belongings and swept clean. The seller agrees to provide a clean title and access to the property. There's a note at the bottom that even if the buyer does not complete a survey during the due diligence period, that it does not relieve a seller of this obligation. Here, the seller agrees to government compliance. On the deed line, you decide how you would like the deed completed, or you can discuss that with the closing attorney. And there's an option to ask the seller to pay for buyer closing costs. The agreement to pay buyer expenses is a great line. It allows buyers to ask for additional funds for closing if they need help paying a deficit in a real estate commission. There's additional disclosures for the seller's obligations to HOA fees and penalties, any repairs, improvements, and there's a spot where a buyer can ask for a home warranty. We'll discuss home warranties in detail. At the bottom of it, we're getting into the meat and potatoes of how HOA fees are divvied up at closing. Now we're getting close to the end. We're to prorations and adjustments, how things will shake out on the closing disclosure, who pays for what when. And then the condition of the property, risk of loss. Again, sellers have to have their personal belongings removed the date of closing, and the property needs to be in swept clean condition. The middle of page 12 is pretty important. If there's a delay in closing, the contract automatically allows for a 7-day extension. We understand life happens, but we will try to avoid delaying closing at all costs. Possession is very important as well. So in North Carolina, once the sale records, so not just closes, but records with the county, that's when the buyer owns the property and officially gets the keys. North Carolina allows for 2 additional options. There's seller possession after closing, where they rent the property back, or there's buyer possession before closing, where the buyer moves in prior to closing on the property. These require additional forms, and we can guide you through it. Here at the bottom, we have disclosures of additional addenda that are attached to the contract. So our lead-based paint, if the buyer is using an FHA or VA loan, or if there's a separate appraisal addendum that would be written by an attorney and provided by your real estate agent. At the very bottom, there's a discussion on assignments, if you're going to wholesale and assign the contract, or if this is going to be part of a tax-deferred or 1031 exchange. Here we have some definitions, the parties, who's involved in the contract, survival, what happens if there's a death or something dramatic happens. Page 14 is pretty self-explanatory. The buyer signs the offer and sends it to the seller. The seller signs it if everything is agreed upon. We get you under contract. Page 15, wire fraud warning. We will never, ever, ever send you wiring instructions. Wiring instructions will only come from your closing attorney. They will come from a secure portal, and it is imperative that you call a trusted phone number and verify these instructions. Wire fraud in real estate is a billion-dollar loss industry. We do not want you wiring hundreds of thousands of dollars to the wrong account. Page 16 is your agent's information. So your buyer's agent and your listing agent. We complete that. And the final page of the offer to purchase and contract is the acknowledgement of receipt of money. So your due diligence fee, your earnest money deposit, and any additional deposits. Well done. You have made it through the longest document in our forms library.